Good afternoon, everybody, and welcome to today's Law Talk Friday. My name is Pete Mikopoulos-Semfleber. My pronouns are he, him. I'm a staff attorney at Lone Star Legal Aid, and I work in our medical legal partnership unit with UT Physicians and Lone Star Circle of Care. I'm also the board president of Trans Legal Aid Clinic of Houston. My background's in civil litigation and employment law, and I have a passion for informing and supporting the LGBTQ plus community here in Texas and beyond. I'm joined today by two wonderful guests from our community partners. I'll let them go ahead and introduce themselves. We'll start with Nick Guillory.
Hi, so I'm Nicholas Guillory. Folks just call me Gilly. My pronouns are he, him. I'm a Tyrone Gardner Memorial Law Fellow at Lambda Legal. My work centers on BIPOC LGBT folks and BIPOC folks living with HIV. Prior to joining Lambda, I interned for the National Center for Transgender Equality, as well as the Maryland Office of Public Defenders Juvenile Division and the Travis County Juvenile Division Public Defenders Office as well. I serve on the board of Transgender Legal Aid Clinic with the PD, and I'm excited to be here today.
Thanks so much, Gilly. Okay, and we also have Nova Jones joining us. Nova, can you go ahead and introduce yourself, tell folks a little bit about you?
Hello, my name is Nova. My pronouns are they, them, and I am the newest community center specialist for the Montrose Center. So here, a lot of the work that I do is centered towards community outreach, programming, events, and any form of advocacy, and then also just making sure that our mission is reflected in all of those things. I'm a Houston native, and so I know the city very well, and I'm just, here to hold it down for the community.
Awesome. Thank you so much, Nova. And we'll get into a little bit more about the work each of our organizations do in just a bit, but it wouldn't be a good legal presentation without a disclaimer. So I do have to say that this presentation is intended to serve as legal information, does not replace legal advice. And if you're looking for legal advice, contact Lone Star Legal Aid at 1-800-733-8394 or go to lonestarlegal.org for more information on legal assistance. So today's topic is Over the Rainbow, legal changes impacting LGBTQ people. The LGBTQ community is a resilient community that has historically been subject to discriminatory legislation and legal frameworks. This systemic discrimination is a major factor that's caused the LGBTQ plus population to disproportionately be impacted by poverty. In the United States, about 1 in 8 people, LGBTQ plus identifying or not, live in poverty. Gay and bisexual men and women are much more likely to live in poverty than the general population. About 1 in 5 gay and bisexual men and 1 in 4 lesbian and bisexual women are living in poverty. This means the GLB portion of the alphabet of the US population is nearly twice as likely to be living in poverty than the US population at large. For transgender people, the statistics become even more staggering. The 2011 National Transgender Discrimination Survey found that more than 25% of transgender people report an annual household income of less than $20,000, and that transgender people are 4 times more likely than the general population to be living below the poverty line. 20% of trans people have been or are currently homeless. Today's discussion will focus on recent legal changes that are showing positive trends for protections and hopefully eventual equality for members of the LGBTQ plus community. Unfortunately, while there have been numerous strides forward for LGBTQ plus folks in recent years, we are still battling unfavorable legal climates. To that end, today's discussion will also cover threats to LGBTQ Texans, including the recent directive to the Department of Family Protective Services regarding reports of gender-affirming care for trans and gender nonconforming youth, as well as some silver linings on these decades-old clouds. We'll also be covering Social Security survivors benefits, employment discrimination protections, and possible expansion of recent Supreme Court decisions. We'll take on some of the more grim things like challenges for the future and recent threats, but overall, we hope today's conversation gives you a little glimmer of hope in what might otherwise be kind of a desperate time for us. Before we jump into the actual substance of the presentation, I'd like to talk about what each of our organizations do. So I'll start off by talking about Lone Star Legal Aid. We are the 3rd largest provider of free legal aid in the United States. We serve 72 counties in Texas, an area that covers 1/3 of the state, including almost 60,000 square miles from Texarkana down the Louisiana-Texas Gulf Coast state line to Matagorda Bay, and into Central Texas, an area with over 2 million Texans eligible for free legal services. LSLA has 14 offices and covers many practice areas, including consumer, landlord-tenant, foreclosure, public benefits, environmental justice, disaster recovery, tax relief, fair housing, family law, domestic violence, sexual assault, crime victims' rights, veterans' benefits, and more. LSLA's Medical Legal Partnership Unit partners LSLA attorneys like myself with participating Houston area medical clinics. These partnerships allow health clinic patients to obtain legal services they need in addition to the healthcare services they need. To learn more about LSLA's Medical Legal Partnership clinics, you can check out our MLP page on LSLA's website, www.lonestarlegal.org. LSLA is committed to providing quality, efficient civil legal representation for low-income Texans. LSLA does not discriminate on the basis of race, color, religion, creed, gender expression, sexual orientation, age, national origin, ancestry, disability, marital status, or military status in any of its activities or operations. I'm also a board member of Translegal Aid Clinic Houston, which is a nonprofit pro se legal clinic that assists adults and minors in Texas with obtaining name and gender marker change corrections on their identifying documents. Translegal Aid Clinic Houston's volunteer attorneys provide valuable resources and information to clinic participants free of charge. Translegal Aid Clinic also offers financial assistance to clinic participants on a case-by-case basis. To learn more about Translegal Aid Clinic Houston, you can visit their Facebook or Instagram pages. And with that, I'll pass along to Gilly to talk about what Lambda Legal does and a little bit more about their organization.
Awesome, thank you, Petey. So Lambda was founded in 1973. We're the oldest and largest national legal organization whose mission is to achieve the full recognition of civil rights for lesbian, gay men, bisexuals, transgender people, and everyone living with HIV through impact litigation, education, and public policy work. We're a nonprofit, so we don't charge for our legal representation or our advocacy. So that's pretty much it. You've probably seen us in a couple of big name LGBT rights cases where we served as lead counsel.
Thanks, Gilly, and thanks for the great work Lambda does. Nova, can you tell us a little bit about the Montrose Center?
Oh, it depends on how much time you have, because to be honest, what I've learned since joining the Montrose Center in November 2021 is that this place accounts for so many services that impact our community in great ways. I mean, we have mental health services, we have trans youth services, we have services specifically targeted towards our seniors who are, you know, kind of in their rainbow years and who need housing, who have food insecurity. We have services that tackle those issues as well. With our Law Harrington Center that actually just opened up this past year. So the Montrose Center has absolutely a lot to offer, and there's so many programs that I want to get into, but I'll definitely save a lot of that for the end of our dialogue when it opens up a bit more.
Sounds great. Thanks so much, Nova. And if you're watching this from the Houston area, you've probably heard of or been to an event at the Montrose Center. Your organization does wonderful things and it seems like just continues to grow. So kudos for that. All right, so let's dive into kind of the substance of today's discussion. Nova, you mentioned that LGBTQ seniors in their rainbow years sometimes need some additional assistance or assistance that we might not be thinking of. A lot of times our focus is on youth and the youth initiatives that are out there. But guess what? Whether we like it or not, we get older, beats the alternative. So we need some services in our later years in life, and those have thankfully been expanded and accounted for recently by the Social Security Administration. So we're going to talk a little bit about Social Security survivors benefits and how those have been expanded to help reach more LGBTQ folks than they have in the past. So we're going to dive into the legal background on that. Gilly, do you mind kind of walking us through what recent updates happened to make these benefits accessible for LGBTQ seniors?
Awesome, yeah. So Lambda Legal filed 2 class actions in 2018, one on behalf of surviving same-sex spouses who were married and but were prevented from receiving services. And then on another class action on behalf of surviving same-sex partners who were prevented from marrying their loved ones at all. These 2 class actions both judgments became final in November of 2021. Courts in both of these cases held that denying Social Security survivor benefits was just as unconstitutional as a marriage ban that we saw in Obergefell in June of 2015. The practical outcome of these two settlements, or cases being final, is that LGBTQ people whose claims for Social Security benefits who would have been denied because they were not able to be married to their partners at the time of their partner's death because of unconstitutional laws barring them from being married can now obtain survivor benefits.
That's great. Just to fill in what survivors benefits are and how they work. Social Security Administration pays survivors benefits to spouses and dependents of a person who has died and who is paid into the Social Security system. The surviving spouse can either collect benefits based on the work record of the deceased spouse instead of their own retirement or disability benefit if their deceased spouse's benefit would have been higher. They can also start collecting a survivor's benefit as a way of delaying retiring on their own record. So as you might know, as you get older, the percentage benefit increases the more you delay your retirement. And so this kind of gives them the ability to buy time to retire on their own record on a later date by using their deceased spouse's record as the basis for their benefits in the interim. Or these folks can receive survivor's benefits while caring for the deceased spouse child. And like Gilly said before, these benefits might not have been accessible to LGBTQ folks because if you were in a same-sex or considered same-sex relationship and you were not able to marry, you could not meet this threshold requirement for survivor's benefits, which required you to be married to that person for a minimum of 9 months. Really hard to get married and stay married for 9 months when the law prevents you from doing that. So that's what those cases that Gilly was just talking about changed for LGBTQ folks. Talked a little bit about the practicality of that, what kind of effect that has for LGBTQ folks. Nova, from a community worker's perspective, can you tell us what these benefits can mean for LGBTQ plus people?
Absolutely. And I'm the type of person, I like to contextualize with some storytelling, but I want to be mindful of the seniors that I've met at our Law Harrington Center and other members of our community and not extract from their livelihood. But from what I've discussed with people, it's just that knowing that you don't have the support for your capacity in your later years, that financial protection and that extra comfort, you're trying to figure out, like, where can I go? Like, how am I going to live? Am I going to be able to go into an apartment complex with these raising rent prices? Even in the city of Houston, there's no affordable housing for me, and I don't have that support system. This type of benefit and the work that Lambda Legal has done and what it's turned into is significant because it provides that extra financial cushion. It increases the capacity of our seniors who don't have that financial protection or who didn't have it before. I mean, these are things that I'm seeing in like day-to-day meetings with our seniors who are like, when my partner passed, I just didn't have anything to go off of. I just had to survive. I had to make it happen for myself. And I hear that way too many times, and it's upsetting, of course, when I'm speaking with them because there's an interpersonal connection there. But just in general, knowing that they didn't have that support before is just very disheartening. And I'm very glad, again, at the work that Landom has done and what it's turned into.
Thanks, Nova, for providing that firsthand lens perspective of that. I think another important thing to note here is that the LGBTQ plus community is disproportionately impacted by poverty and unemployment and underemployment. This is especially true for trans people. The National Center for Transgender Equality and the National Gay and Lesbian Task Force released a comprehensive study on transgender discrimination and revealed that 90% of transgender individuals have encountered some form of harassment or mistreatment on the job. And 40%, so almost half of transgender folks, experienced an adverse job outcome because they're transgender. And that could mean getting fired or passed over for a promotion. So I think when you're starting out with a population that already struggles to make ends meet and is impacted by employment discrimination, and then you add on top of that, by the way, you might not be able to get these retirement benefits that you would be entitled to if you were in a opposite sex presenting relationship. That just adds fuel to the fire and makes things worse for those folks. So I think as a whole, these decisions are going to have a huge outcome for our LGBTQ seniors. And also, that's leaving out the fact that we also have a wage gap, an LGBTQ wage gap. We hear a lot about the gender wage gap, but we don't often hear about the LGBTQ plus wage gap. Gay men earn 10 to 32% less than similarly qualified straight men, and trans people are twice as likely to be unemployed than cisgender people. So again, when you're starting off with an unlevel playing field and then you're adding more slopes to it and hurdles, it just makes things more and more difficult. So thank you very much for kind of coloring in what this means to our community. I think the next question people will have is, what kind of information do I have to provide to Social Security? How do I make this happen? Like you're saying, Nova, you helped some folks that were kind of lost about what to do and struggling on their own. So how can you actually put the wheels in motion and get these benefits? Well, I think Nova is going to give us a little bit more information about how you actually get the benefit claim. But first, you have to think about what kind of information are we going to be asked by Social Security to kind of prepare yourself and be ready. So Social Security is going to be conducting inquiries to determine if, whether, and when you and your partner would have been married if there had never been any discriminatory law preventing you from getting married. So to determine this, they're going to ask you questions about your relationship history. So some of these questions might be as simple as, would you have been married if there were no law barring same-sex couples from marriage? That's a pretty straightforward question. If you're applying for these benefits, it's probably going to be yes. And then they might ask, if you were to get married, when would that have been? That's to determine that it would have been at least 9 months before your partner's passing. They might also ask if the state barred same-sex couples from marrying at all times before your partner's death to see if this were available and you could have done it. Would you have? They might also ask if you were in a committed relationship. Did you rely on each other financially? Did you live together? Did you consider one another family? Did you share joint responsibility? And they might also ask if you provided for each other after death. Like, did you designate one another as beneficiaries in a will like spouses normally do? Did you have some sort of informal commitment ceremony that could have been interpreted to be a wedding or marriage had that been recognized by the government at that time? Did you raise children together? So there's a long list of questions that the Social Security Administration has been trained up on what to ask for when you're participating in one of these interviews. The common thread for all of these questions is that they have the same goal in mind, determining whether you and your partner would have been married if the law let you, and whether you would have been married for at least 9 months before your partner's death. In addition to these questions, they can also ask you to submit documentary evidence to support your claim, including powers of attorney designating your partner as the agent, or if you had a healthcare directive designating your partner as the agent, life insurance policies with your partner designated as the beneficiary, joint bank accounts, all those things that kind of prove up, yeah, we were operating just like a, cisgender, opposite sex couple would have been married. We just didn't have the legal stamp of approval on it because the law didn't let us. So even informal things like photos or cards or documents that demonstrate your partnership history and commitment can be used as evidence for these things. So if you have them and you're looking to submit one of these survivors benefits claims, gather them up and be prepared for your Social Security interview so that you can answer these questions. It should be relatively easy to answer because they're about you and your life, and hopefully you have a pretty good handle on, the specifics of what to answer, but it sometimes helps just to know what's going to be expected. The Social Security Administration staff should consider all the evidence you submit to determine if you would have been married were it not unconstitutionally barred for you to do so. So there's not a right answer or a wrong answer for these things. There's no smoking gun document to prove that you were married. They have to consider all the circumstances. So just make sure during your interview you answer honestly and truthfully, and that you provide all the background that they need to get to this determination. And if you are in one of those committed relationships, it's highly likely you have a lot of these things going in your favor. One question I think people might have is, if your partner passed years ago, you probably should have been getting benefits then, but unfortunately these decisions are relatively recent, and so you have not been receiving benefits for that time. Can you kind of look back in time and get past benefits Gilly, I'll ask you that. Do these folks that are now qualified get to say, my partner died 10 years ago. I want benefits dating back to then. Will they get them?
I hate to give this lawyerly answer, but it depends. So if you've previously been denied solely because you didn't meet the marriage requirements due to discriminatory marriage laws, you can request that Social Security office reopens your claim. If you're ultimately approved, you should receive benefits dated back to at least the date you originally applied. If you file a new claim instead of having your claim reopened, you may only receive benefits from the date of the new claim going forward. So if you were deterred, and so there's another option. Let's go with that you were deterred and you didn't apply at all. You're denied the ability to even submit an application because staff members told you otherwise. You have the option to submit a new application, and when you do so, you can request that it have a deemed filing date, or basically that the new application be treated as if you were filed on the date you initially attempted to, but were prevented to by the staff. So if you did this, you will likely have to provide a signed statement indicating how you were misled or misinformed by the staff members when you initially went to submit the application. The determination of the date of your benefits should begin is made on a case-by-case basis based on your original application, your deemed filing date, and other circumstances surrounding your application.
Okay, great. So it's a case-by-case determination, kind of unique to each individual and their circumstances or what came up for them. Okay. This sounds great for the folks that qualify. This is fantastic news. Again, thanks to Lambda's work. Nova, how do people that think they qualify apply or reopen their application, as Gilly was just explaining to us?
So the best way for people to see if they can get these benefits is they should reach out to the Social Security Administration by phone. And you can reach them at 1-800-772-1213, or you can call your local Social Security Administrative Field Office by their phone number. So you just have to find it on their website, the local website. You can't apply for these benefits online, which is why we're suggesting that you do this over the phone. Because they just don't have the same capabilities of like handling your application online. And then also the field offices are closed up until potentially March 30th, 2022. This could potentially change. So again, if you're looking to see if you qualify for these benefits, I would just continuously check in with that local office to see whether or not they'll be open again for in-person visits. Now, to apply, you will need both your Social Security number and you're going to need your deceased partner's Social Security number. You should also be prepared to answer questions related to your relationship, just as P was offering us earlier. Just be open and honest about your case, about your situation. Provide as much information that's pertinent to your relationship as possible. During your appointment, you should inform the Social Security Administration staff that you believe your application falls under a few different classes, which is the class certified in Ellie versus Saul, and that your claim should be processed according to emergency message EM 20046. This is a review. And now if you're married and not like within that 9 months space, this is also, again, another reason or another class that you want to look into. And then a Thornton ruling pursuant to the emergency message if you were never married based on unconstitutional marriage laws. So this, again, just pointing to both cases and how they made this benefit more accessible thanks to Lambda Legal.
Awesome. Thank you, Nova. Okay, so that is one piece of good news, a good news update, especially for our LGBTQ elders and those looking to get their deceased partner's benefits that they are now entitled to. Another good thing that's happened recently, well, it's getting a little older now, but it's the good thing about this opinion is that it's making waves. It's changing the scope of some other laws, and we'll get into that. So the case we're going to talk about is Bostock versus Clayton County, Georgia. Gilly, do you mind giving us an overview of this case and the outcome?
Yeah, so Bostock versus Clayton County, Georgia. It was a landmark Supreme Court case that held that Title VII protects employees nationwide from discrimination based on their sexual orientation and gender identity. The Bostock opinion analyzed 3 cases where longtime employees were fired simply because they were gay or transgender. The first case, Gerald Bostock, was a county employee for Clayton County, Georgia, who was fired because he joined a recreational gay softball league, which the county believed was unbecoming of a county employee. In another case that was consolidated in this opinion, Daniel Zarda was fired by his employer because after he mentioned that he was gay. And in the third consolidated case of Amy Stevens, a transgender woman who presented as male when she was hired by the funeral home she worked for, was fired after she told her employer that she intended to live and work full-time as a woman. So Title VII is a federal employment law statute that makes it unlawful for qualifying employers to fail or refuse to hire or to discharge any individual or otherwise discriminate against them because of their race, color, religion, sex, or national origin. Qualifying employers are those with 15 or more employees. The court's opinion essentially found that gay and transgender employees, such as Mr. Bostock, Mr. Zarda, and Ms. Stevens, were discriminated against because of their sex, because an employer who fires an individual just for being gay or transgender fires them for traits and actions that it would have questioned in members of a different sex. Sex plays a necessary and indistinguishable role in the decision, and that is what Title VII forbids. Accordingly, the court held that the protections Title VII afforded against sex discrimination encompasses sexual orientation and gender identity.
Thanks, Gilly. So I think, sometimes lawyers have the tendency, and legal opinions have the tendency to make things sound more complicated than they are, but I think you broke it down well for us. The court basically found that Title VII, which says you cannot discriminate because of sex, covers sexual orientation and gender identity because, let's say, for example, I was in a relationship with, I presenting as male and identifying as male was in a relationship with a woman. My employer probably wouldn't have a problem with that because that is not a same-sex relationship and they probably would not have an issue. However, if I was in a relationship with someone that presented or identified as male, my employer may have a problem with that because that looks to them like a same-sex relationship. And therefore, they may have discriminated against me based on that. And the court was saying when it turns on the decision about whether they're discriminating against me or not, turns on my sex, that falls under Title VII. Is that the correct interpretation of it?
Exactly. I say if an employer can't describe why they're firing you without using the words their sex, then it's forbidden under Title VII.
Okay, great. And so previously it did not necessarily encompass sexual orientation or gender identity. So it left LGBTQ plus folks vulnerable to this discrimination because there wasn't a protection for it. Nova, can you tell us from your perspective how workplace discrimination laws like this impact LGBTQ plus people?
Absolutely. As a non-binary person, this is a concern that I'm always having. My colleagues are trans or just not cisgendered, heteronormative, like they have to have these concerns. And it's because LGBTQ people are more likely to be unemployed or underemployed than any other person. And before this opinion, like you said, there wasn't really any protection. There wasn't really anything there, a legal precedent that said that we can be protected under Title VII. And so that was the significance of this case, knowing that, I mean, if you have this legal education or if you have education of these cases, knowing that you have that Title VII protection and that your employer cannot, like make you quit or demote you or change your salary just because of your gender or your sexual orientation is significant. And just having that and being able to engage in your workspace with that protection, just makes you show up completely differently. Like you get to have a different capacity. You get to advocate for yourself and the workspace and who you want to be. Like we should be allowed to be ourselves wherever we are, but especially at work, we need that validation.
That's great, Nova. I completely understand the perspective. And I think it also just it feels like a moral victory for the community to have the Supreme Court, the highest court in the land, validate and hand down this opinion saying that your sexual orientation, your gender identity, that matters, and we want to protect you from discrimination based on that. In one of the arenas that changes your life, I think we think about family and other law types like family being the most crucial for your life, but your job is your lifeblood. A lot of times it determines what you can and can't access, and sometimes it determines whole outcomes in your life. So protection in the employment arena, I think, is critical. So what is the practical application of the Bostock opinion in the employment context? So it's a great victory for LGBTQ plus people for the reasons that Gilly and Nova just articulated, but there are some practical realities that hamstring the Bostock opinion from being this earth-shattering, bomb for us. First, to be protected from discrimination based on sex under Title VII, you have to work for a covered employer, which, as Gilly mentioned, is an employer that has at least 15 employees for at least 20 work weeks in the current or preceding calendar year. This sounds like way too many numbers for me. So in simple terms, if you work for a very small employer, a mom and pop business that has 9 employees, the Bostock outcome is not going to help you because that employer is not a covered employer under Title VII. There are thousands of small US businesses that are not covered under Title VII. And for those businesses and those employees, unfortunately, this opinion will not impact them. Second, employees that bring these claims have high legal burdens to establish that they're entitled to relief. This is especially true in jurisdictions like Texas and in the Court of Appeals circuit that encompasses Texas, the Fifth Circuit. What this means is while you can legally have a viable claim for discrimination based on your sexual orientation or gender identity under Title VII, the evidentiary burden to actually meet and prove that claim and obtain recovery is very, very difficult. A lot of employers are very shrewd and know what they should, not put in emails and not say if they're being recorded or monitored, and can make these decisions in a way that don't give rise to the standard of discriminatory animus because they'll find some other thing that you were doing to kind of shift the burden. So that sometimes is a challenge. Also, Bostock did not change state laws prohibiting sex discrimination. Texas has a state statute that's very similar to Title VII, which protects against discrimination. And this is called the Texas Commission on Human Rights Act, or TCHRA. And the Bostock decision did not change that law or any other state's anti-discrimination and employment laws. The good news here is that some Texas courts have held that the Supreme Court's interpretation in Bostock applies to the TCHRA, meaning the Bostock opinion did change our state law, at least in these courts' opinion, and effectively expanded the coverage of the TCHRA as well. Other state discrimination statutes have been expanded in the same way across the country, and more could soon be officially adopting the Bostock interpretation via opinions or their legislatures. So that's great for a couple of reasons. And one of those is that some states' laws apply to smaller employers than Title VII, and some offer additional remedies or damages than Title VII. Texas isn't one of those states, but if you're in one of those states, you might be able to state a claim under the state anti-discrimination statute and your employer be covered even though it's a smaller one, or you may be eligible for additional damages if you're in one of those states. Finally, Bostock is limited to Title VII's employment discrimination protections. This means it doesn't apply to other anti-discrimination laws such as Title IX, which is what governs education, discrimination in education. So those are some of the restrictions on Bostock, but we definitely see a world, and are seeing more and more, a world where the Bostock opinion is expanding to these other anti-discrimination statutes. Gilly, can you explain what we've seen and what we might see in the future with regard to Bostock infiltrating other arenas?
Of course. Honestly, Bostock is popping up in many different arenas. So we see it in the education realm, housing, and immigration. So Executive Order 13988 was issued by President Biden in January of 2021. This executive order stated that the expansion of non-discrimination protections under Bostock should be applied to Title IX of the Education Amendment, the Fair Housing Act, and Section 412 of the Immigration and Nationality Act. The executive order directed all federal agencies to review all policies which implement the non-discrimination protections on the basis of sex ordered by Title VII, Title IX, and the Fair Housing Act, as well as the Section 412 of the Immigration and Nationality Act. And they did that to just make sure that their processes were consistent in applying sexual orientation and gender identity as well under those protections. So we may see expansions of Bostock to all state anti-discrimination laws in the employment context and beyond, as well as in various other anti-discrimination laws that forbid discrimination based on or because of sex. Additionally, we find the arguments in Bostock very persuasive for why LGBT folks should receive constitutional protections as well, which will have major implications for the rights of LGBT folk across the country.
All right, so we'll just have to be keeping our eyes peeled for how the Bostock opinion changes all of these other anti-discrimination lawsuits. But it sounds like we're on the right track. All right. Okay, so Nova, can you tell us what the expansion of Bostock, if we were able to move it beyond just employment, what that could mean to our population?
Absolutely. And we love the legal and policy advancements and how it's supporting our community. But we have to be mindful of how discrimination against LGBTQ folks is everywhere. I mean, it's pervasive. The tentacles touch us in every way, whether it's at work, whether it's at school, whether it's like at a medical facility, whether it's in the courthouse itself. You know, the discrimination that you can experience and the way that it makes you repress yourself or be a lesser version of yourself. You can't even show up because you have to survive. LGBTQ folks know that it's not always the case that the space that you're going into is going to be a validating and affirming space for you to exist in. And if you know that and you know you have to survive, you have to show up to work a certain way. You have to perform, even in school, in all these spaces. And so what Bostock means, what this case gives us materially, is that we get to show up to these places, again, with that comfort of my workspace cannot discriminate against me. You know, they cannot fire me for being trans. They cannot fire me for being a gay man. They cannot fire me for being lesbian. Like, they can't take away my ability to survive through this paycheck and through the benefits that I get at this workspace. They can't take those things away from me just for me being who I am. And knowing that, knowing you have that legal protection behind you, and of course, if this continues to expand for us, just having more of that security, again, makes us feel like we can be the fullest version of ourselves. And that's really what we want. I mean, that's the intention about fighting against discrimination, is I want to come to work and not be concerned about if people are going to erase who I am when I walk in the door. You know what I mean? So I think that's very significant. I feel like, so personally, I've been dealing with this a lot over the last couple of weeks, of course, because of everything that's going on in the state of Texas and where I'm living. And one of my mentors that I'm really close with, she's a trans woman who's been doing community activist work for decades. And she's just reached a point to where she's like concerned about her survival because of the attacks. But then at the same time, we reflect on these cases and like, we're making strides. We're doing what we can. Like, how do we keep going? And what she offered to me was that, like, we really, really, really have to build up our collective capacity as a community. We have to continue to show up for each other, because things that happen in Texas can make us feel tired and exhausted. Then we have to look at Bostock and get reinvigorated, you know, by the work and the goodness that came out of these cases. So we got to keep going. That's the only way to put it. We got to keep going.
That's a great perspective. Strength in numbers for sure. And again, it's collectives like these where we're just pooling all our resources and our brain power together to help lift up the community. I'm going to quote one of the great poets of our time, Miss Katy Perry. After a hurricane comes a rainbow, she said. We've tackled the rainbow, all the good stuff that's happened. Let's go into the hurricane a little bit. But let's talk about kind of the umbrellas we can put up to shield ourselves from the rain on this hurricane, okay? So I'm going to start with the recent directive regarding trans youth. It's a super hot button issue, and our focus on this is going to be what you can do if you're subject here to some of these actions to get help and reach out to your community. Like Nova said, strength in numbers. We all have to be together and reach out to one another and make sure we're okay, check in and push each other up. I'll give you some background on this. Texas officials have begun investigating parents of transgender and non-binary minors for possible child abuse based on a recent directive from the governor. Here are kind of the bright line takeaway points from this. We have to note that no court here in Texas or anywhere else in the country has ever found that medically necessary gender affirming care can be considered child abuse, which is positive. You and your family have rights to privacy, and you don't have to disclose whether your child or teenager is transgender, nor do you have to disclose any private medical information to anyone. You have a right to an attorney, do not have to speak to anyone from DFPS, also known as Child Protective Services, or law enforcement without an attorney. Earlier this week, the U.S. Department of Health and Human Services issued guidance on gender affirming care, civil rights, and patient privacy. Within the guidance, the department explained that parents or caregivers who believe their child has been denied health care, including gender affirming care, on the basis of that child's gender identity, may file a complaint with the Office of Civil Rights and healthcare providers who believe that they are or have been unlawfully restricted from providing healthcare to a patient on the basis of that patient's gender identity can also file a complaint with the Office of Civil Rights. This federal guidance also reminds providers that HIPAA prohibits disclosure of gender affirming care that is protected health information without an individual's consent, which is a valid HIPAA authorization, except in very limited circumstances. If you believe your or someone else's HIPAA rights may have been violated, you may also file a complaint with the Office of Civil Rights. You can file a complaint on the Office of Civil Rights online portal, which we are going to include here. Obtaining gender affirming care is already difficult for most trans and non-binary people, especially those in rural areas, and even more so for those with lower incomes. For context, gender affirming care, like most medical care, is unique to each individual. The prevailing medical standards of care apply to determining what care is right for each patient. Gender affirming care is an umbrella term, and it can include puberty blockers, mental health care, or hormone replacement therapy, among other things. Gender affirming care has been proven to improve health and life outcomes of trans and non-binary people as children and adults. Studies show that youths who received puberty blockers or gender affirming hormones were 60% less likely to be depressed and 73% less likely to have suicidal thoughts compared to youth who did not receive those medications. Trans and non-binary mental health and suicide rates are shocking and abysmal. According to a study by the American Academy of Pediatrics, between 30 and 50% of trans and non-binary youth have attempted suicide. This is just an unacceptable figure. Some state Medicaid policies explicitly include medically necessary care for transgender people. Some state Medicaid policies explicitly exclude such care, and some states have no explicit policy either way. Texas's Medicaid program explicitly excludes this care, meaning that gender affirming care for trans children and adults on Medicaid has to be paid out of pocket and will not be covered. About 3 in 10 LGBTQ Americans report difficulties accessing necessary medical care due to cost issues. For trans people, this figure is 1 in 2. Following the governor's directive last week, the ACLU, Lambda Legal, and Baker Botts filed a lawsuit against Governor Greg Abbott, Jamie Masters, who's the commissioner of the Texas Department of Family and Protective Services, and the Texas Department of Family and Protective Services. Gilly, can you give us some description of this lawsuit from your perspective as one of the attorneys working on it?
Yes, I'll try and keep it brief. Essentially, we sued in Texas State Court to block the Texas Department of Family and Protective Services from investigating parents who work with medical professionals to provide their adolescent children with medically necessary gender affirming care. We also represented a doctor as well.
Okay, great. And I think you recently had a hearing, at least on part of that lawsuit. It's a little complicated. It's a little bit of civil procedure, but it's something called a TRO, or temporary restraining order. Can you tell us a little bit about what that means in simple terms?
In simple terms, we asked the court to kind of maintain things how they were previously to the directive and the BFPI's policy. The judge did grant our order, but only in regards to our plaintiffs. Next week, we'll have a temporary injunction hearing to see if the restriction will be statewide.
Okay, so from a non-attorney perspective, there's been sort of a victory, at least for a Band-Aid fix for a small group of people. And then we have a potentially larger Band-Aid coming after the TI hearing.
Yes, and folks might have heard the order from earlier this week was appealed, but we're working to see just exactly what those implications are of that appeal.
Okay. And I know this is changing by the day, so this is something that we'll all just have to stay on top of. And we appreciate you and your team at Lambda working so hard on this case. So that is kind of, one hurdle that we're dealing with recently is this new directive. Another kind of a gray cloud that we've got here is there are some cases coming up to the Supreme Court, which we think are likely to have unfavorable outcomes for the LGBTQ plus community. One case that will be heard this term is 303 Creative. And this is a case regarding whether businesses have the right to openly refuse services to LGBTQ customers. We do think that's probably going to go the way of the business and say that they do have the right to openly refuse services to LGBTQ customers, but just a prediction. We'll have to see how that pans out. Going forward in future terms, we will probably see more of these cases come up. So it's just an evolving conversation. Like Nova said, we just have to stick with it. We have to stay strong and keep moving forward and see where we can go, because there are some victories here to kind of give us that pep. Nova, what do you think are some of the challenges as a member of the LGBTQ community and somebody that lifts others up in these new battles that we seem to have pretty frequently here?
I think the biggest challenge is having the energy. I mean, I leave work and I take work with me. I'm gonna be honest, I'm one of those people. I can't go home and just divorce myself from the experiences that I've had with the youth and our seniors and other people who come and need the services of the Montrose Center. Like, I take that with me, and it's draining for me personally, but I can feel in the conversations that I'm having with people that they're tired of trying to plead for their own survival and feeling like they don't have that support, that backup, that allyship that makes them feel secure in this fight. So it is draining, and of course we do have things that we can hold on to, but we need that continuous support. We need that morale boost consistently with people showing up and supporting our capacity. Like you said, Pete, checking in. One thing that I thought about, as you said this, when you were speaking towards specifically the issue that our trans and non-binary youth are facing when it comes to suicide rates, is that if you are dealing with invalidation as a unique minority stressor based on your gender, that's going to make you feel like wherever space you go into, no one's going to see you. You're completely invisible. So here at the Montrose Center, we're really, really focused and dialed in on, like, we have our Hatch Youth Prom coming up this year. And this is the first time in 2 years that we're actually able to do this in person because, of course, we've been navigating a pandemic for the last 2 years. Think about how significant that is to our kids who are coming back for the first time in a few years and being able to go into a space of celebration, of joy, of having that morale boost. Those moments, those events are the things that we're holding on to and saying, like, there's hope. We're going to give you this space. It's going to be a good one. We're going to dance. We're going to have fun. People are going to support this with their donations, through all the other events that we're doing throughout the year. We need those moments. We need our Pride Parade that's coming back in Houston this year in June. We need those celebratory moments on top of the things that we're doing legally and in policy.
Yeah, that's exactly right, Nova. And I think your organization does that for so many of us in the LGBTQ community. The Montrose Center truly is a focal point of those celebratory moments. And even those not so celebratory moments, when we need those shoulders and those people to lift us up, you guys have such fantastic community outreach programs and programs for everybody, from 1 to 92. You can come to the Montrose Center and find something for you. So let's end this on a high note. Hope for the future. It's definitely out there. Gilly talked about, we've got, the TROs granted in Lambda's favor. We've got the TI hearing coming up pending an appeal. There's potential in your lawsuit to result in an outcome in your favor. That's a silver lining in my book. Community efforts and support. Nova, what can people that might be impacted by these recent challenges do right now to kind of mitigate the tailspin that they're in?
So one thing that they can do is that there are grants available for families with trans youth in their families in Texas, and that these families may be able to obtain a rapid response grant for $250 to help cover the cost of legal services, emergency planning, mental health support, and more. And again, that goes back into increasing or supporting those families and their capacity as they're continuously dealing with this struggle and this fight here in Texas. And so in order to do that, you can apply through the Southern Equality Fund, and there's going to be a link provided for that. Also, Lambda Legal, and Nicholas will be able to speak to this too. The ACLU of Texas and others are offering support and legal assistance to the families that are impacted by the reports of this abuse that was written in this opinion. And then also there's TexasTransKids.org, which is a very modern resource online. It's a collaborative effort between the ACLU, Lambda Legal, Equality Texas, and the Transgender Education Network of Texas. There's a host of mental health services and other resources for trans kids and the families who are supporting these kids. Again, this resource is relatively new and it's constantly being built into. So there's going to be more things that we can pull from that. So like you said, Pete, we want to end on a good note. There are resources out here. There is support. There is community. There is some form of solidarity that we can experience. I know sometimes it might be difficult to find, but that's what we're here for, is to provide you that bridge.
Excellent. Thank you, Nova. And we're going to share these links in the chat here in this video. Again, southernequality.org has grants available to trans youth, families of trans youth. There are also a wealth of resources on TXTranskids.org. Lambda's Help Desk and the ACLU are offering a lot of support for families of trans youth that are experiencing difficulty right now, or in the future. These resources thankfully remain, whether we're in a storm or have bright skies, they're there for you. So with that being said, I really want to thank our speakers for their time. Thank you both so much. Gilly and Nova, you provided such great insight. Nova, I do want to give you a chance to plug any upcoming volunteer opportunities or things of interest at the Montrose Center. So if you don't mind.
Yes, if you want to support our efforts, we do have a few opportunities coming up for 2 events specifically. We have our Bunnies on the Bayou event where we're partnering with a local LGBTQ organization for this event, and we do need some volunteers for that. And then we also have our Bringing in the Green event. Now, both of these events are also going to be supporting the work that we're doing here at the Montrose Center through fundraising. And so we absolutely would love either the volunteerism that you can offer, or if you just want to attend these events and have a good time and purchase the tickets, that's going to go to a good cause regardless. So show up in any way that you can, and please come out and be in community.
Thanks so much, Nova. I think those are definitely things that we all need right now and pretty much always. I'll plug Gilly and I's clinic, Trans Legal Aid Clinic of Houston. We've got upcoming clinics for adults and minors looking to correct their name and or their gender marker on their identifying documents. Those next clinics are going to be held March 17th at 6 p.m. Central Time and March 19th at 11 a.m. Central Time. Sign up is required to attend these. They're going to be held virtually, so you can wear your pajamas to them while you get advice from our volunteer attorneys if you'd like. You have to sign up again, and the sign up link is on our Facebook page, which will be shared here. Gilly, do you have any final words?
Just want to reiterate what y'all said. If any families of trans youth have any concerns or are impacted in any way by the recent orders and actions, please reach out to the help desk, reach out to ACLU Texas, and we're here to help.
Thank you. All right. Well, again, thank you both very much for your time. Look forward to hopefully more positive updates for our community in the future, and appreciate the work both of you are doing. And with that, I hope everybody has a great weekend. Thank you so much.